let's call the case. Patrick Tatora versus Martin Young.
Good afternoon, Your Honor. May it please the court, Eric with that B65354 on behalf of plaintiff.
And Teresa Young.
Good afternoon, Your Honor. Darwin Fair on behalf of Martin, Teresa Yance, and they are here present in court today.
Yes, I do see them. They are here. All right. And go ahead.
Thank you, Your Honor. This is plaintiff's motion to lift the stay, enter an order of eviction, and release all funds that are held in escrow by the court to the plaintiff. This is the way a quick background. This case was filed in October of 2020. This court entered a judgment in November of 2020. However, there was an escrow order put in place at that time because there was a circuit court action that was filed in title. That circuit court action now has been fully disposed of, which I attached to my motion were granted plaintiff's summary disposition, awarding title to the property to Mr. Tortora. Therefore, since this stay was only until the disposition of that case, now it has been, I'm asking the court to lift the stay, to enter the order of eviction, and to release all funds held in escrow to plaintiff Patrick Tortora.
Mr. Fair.
Well, Your Honor, we did supplement our answer to the plaintiff's motion to lift stay and to release escrow. As the court may know, the underlying case is currently before the Michigan Court of Appeals. There's a high likelihood of success because that case is about an unsigned agreement between the parties. And there was substantial actions between the parties after this unsigned agreement occurred. And that includes emails. So we believe that there's a high likelihood that this case will be overturned in the Michigan Court of Appeals. So that's really number one. But number two, Judge, with regards to the escrow, my clients have followed the court's order to the T. They have made all the escrow payments. My understanding that they have paid over $115,000 in escrow, and that doesn't even include the $60,000 they paid directly to the plaintiffs in this matter. And the obvious concern, Judge, is that if the Michigan Court of Appeals rules on behalf of my clients, then there is almost impossible, as the court can imagine, that my clients can retrieve this $115,000 from the plaintiff in this matter. I think the prudent course to take, since my clients have complied, since we're talking about a substantial amount of money, since this case is currently before the Michigan Court of Appeals, that the court exercises its discretion and continues with the stay and holds on to the escrow pending the outcome of the Michigan Court of Appeals case. My clients are here today. Obviously, they are extremely concerned about this $115,000 plus that they paid in the escrow. They do want to hold on to their home. They have prosecuted this case. They've continued to prosecute this case. And it is discretionary on the court's part as to whether to continue with the stay. But I will point out to the court that we did go before the circuit court with regards to a stay of the court's decision that was before the Washtenaw Circuit Court. And the judge's position, which is rightly so, that the stay is automatic in the circuit court when you're going to the Michigan Court of Appeals. So from the court's position, it was like, there's no need for a stay. There is a stay. And so we would just ask the court to follow what the circuit court has done with regards to the stay and to exercise its discretion. My clients are here today to show the seriousness in it, and it is a substantial amount of money. So I think this, in our opinion, Judge, and based upon the facts of the case, that we believe there's a high likelihood that the case will be overturned, that the court exercises this jurisdiction, continue with the stay, and hold on to the escrow. And I believe my clients may want to address the court, so I will defer to them at this time.
State your name, please.
Martin Yance.
All right. You need to come to the podium if you would. Go ahead, sir.
Hi.
If you want.
As you know, we've been fighting this for a long time. First, it was with Chase Bank. My wife and I had, really, we paid cash for this house. We built it, took us a year and a half. Our kids, 4 kids, we all worked on that house for a year and a half, got it completed, and it's on 30 acres, beautiful piece of property. The only reason we ever had a mortgage on it is my son had 16 heart surgeries, and we ran out of money. I had to take a mortgage on it. And, you know, this gentleman, Pat Tora, offered to help us. I went to a law firm called Babby Law. There was a gentleman there that was an expertise in real estate. He used to own his own mortgage company. His name was Matt Attard. I had Pat Tora talk to him and make sure all the agreements, the paperwork was right. We agreed on the terms, and this mess happened. I mean, the guy refused to sign. Well, there's an affidavit from him. I don't know if you've ever seen this. Would you like to look at it?
Well, what is it?
It's an affidavit from Matt Attard.
Well, I don't know. I don't know.
Okay.
I don't know that that's necessarily relevant.
Anyhow, he explains how it happened. But anyhow, we're going to fight it, continue to fight it. We'll end up with that piece of property back, I'm assured. I mean, we've never been late. When our mortgage was through Washington Mutual, and they went out of business and went to Chase Bank, we continued making payments. And then Chase Bank called up, it wasn't just us, thousands and thousands of people's loans for no reason. And even though we continued to make the payment, they actually sold our house at sheriff's sale for I think it was $45,000. But it's crazy that we're in this situation. That's our retirement. We have over $1 million wrapped up in that piece of property. That's really all I would say, Judge.
Yeah, if I may add, that affidavit that Mr. Yance is making reference to was the affidavit of an individual who was at the closing for this property with Mr. Totora, the plaintiff in this case. And they were all there, ready to go. All the documents were ready to be signed. And Mr. Totora didn't show up. And so that's what the litigation was about. It is an unsigned agreement. So it's not like they had this oral agreement. It was an agreement that the parties had agreed to, but Mr. Totora didn't show up. And they went forward with the closing. And then after the fact, he refused to sign it. And he did everything in furtherance.
What you need to know, though, is that Mr. Tora's wife owned the closing company, the title company. And I've known her for a long time, and she promised us she would take the paperwork home to her husband that night and he'd sign it. And now we're in this mess because he didn't.
Yeah, and lastly, Judge, what I also point out is that this is not the only time Mr. Totora has done this. The similar, almost identical situation is before Judge Ewell in the Wayne County Circuit Court, where Mr. Totora did the same exact thing in terms of the documentation. So he's got a history of doing this, and it's just highly unfair to allow the escrow to be given to Mr. Totora under these circumstances. And it's not like, he's not, well, Judge, I don't have to tell you about escrow. You know that he will still be in a position of not being harmed as long as the court has the money. And Mr. Yance and Mrs. Yance will continue to make escrow payments.
Thank you.
Is there anything you wanted to say, ma'am? Is there anything you wanted to say? You're good? Okay. You're welcome. I guess my question is what harm is there to plaintiff if they're continuing to make payments to the court? And I mean, ultimately, what harm comes to the plaintiff?
The defendants do not reside in the property, Your Honor. It's been abandoned. And the concern is for vandalism or any damage or anything else that could happen when you have a residential home that has no one in it and no one looking over it.
I've been going there every day for 5 years. I go there every single day.
But there hasn't been hold on, sir, please. But there hasn't been any vandalism or anything. I mean, when you tell me that, that sounds like something speculative that may happen in the future regarding this particular piece of property. And so you should give us some money, and I don't know how that prevents what you're claiming may be a problem.
No more speculative, Your Honor, than Mr. Ferris asserting that he thinks there's a high likelihood of success on appeals.
I didn't address Mr. Fair. I'm addressing you. And I'm saying what harm comes to the plaintiff if the court is holding the money pending the final resolution, whenever that may be, of this case.
My client's paying all carrying costs,
He's what?
paying all the carrying costs,
What costs have they incurred?
property taxes and insurance.
And how much is that?
I don't have the exact number in front of me, but it is in excess of the escrow payments.
The property taxes?
Yes, it's not 30 acres and it's a very large residential home.
There's about $115,000 in here. And you're telling me on 30 acres, and I know where the property is located. I know Washington County very well. You're going to tell me the taxes are that?
It's been over 4 years, Your Honor.
For 7.
Hold on. I live on 10 acres. And I'm going to tell you what, if in 4 years, well, I guess we have to triple it. If I had $100,000, not a chance. We're Washington, not Oakland County. Excuse me.
As I referenced, Your Honor, I have not seen the text, but I don't know exactly what.
So you don't know?
I disclosed that before. I do not know the exact number of taxes.
I just don't. Can you give me any other harm? I mean, these folks are convinced enough in their position that every month they've been paying. I would know. I have, it seems like, thousands of escrow orders. They haven't missed a heartbeat on any of these payments. It is paid into the court on time. So I don't look at this as something where they're attempting, by filing to the Court of Appeals, to just delay and string out this matter. And plaintiff wants the escrow, but at some point, the escrow is going to have to be disposed of. That's clear. But I don't understand why now. Why don't we wait until the litigation is finished?
We don't know when that's going to be. And Your Honor's escrow order with the stay was clear that it only went until the circuit court came.
Well, I can issue a new escrow. I mean, but I don't want to do that if plaintiff can show me some reason why I should hold or I should release this to plaintiff when the litigation is not finished.
Your Honor, your order from.
Okay, let's get rid of that because I'll just change it. If that's your argument. I mean, I'll just change the order. I mean, again, counsel, I am asking just because the court will, in certain respects, would require me to try to figure out and dispense with the escrow as justice would require. I'm trying to figure out what harm comes to plaintiff if I don't release it. I get their side. They're actually paying on a piece of property that they don't know in the end if it really is going to be theirs. I mean, they're litigating it, but they don't know. But they're paying faithfully every month. And so I'm trying to figure out what harm comes to plaintiff if it takes the Court of Appeals a year and they're paying. What harm?
As I've mentioned before, it's the carrying costs and then not having the ability to access and use the funds for other purposes.
But I don't know that it will be the plaintiffs to use, do I?
It is a plaintiff's to use.
What, by just your pronouncement? I mean, how do I know in the end of the litigation that it will be plaintiffs, that the escrow would be released to the plaintiff?
Because that goes to the carrying cost of what my client has paid for over the 4 years of the litigation.
If the defendants are successful, where do you think the escrow goes?
My client?
If the defendants are successful?
Yes.
Oh, okay. Well, there may be the part of the problem as to why you think you deserve it. Here's what I'm going to do. I'm not releasing any of the escrow. What I'm going to do is Mr. Fair, you'll prepare an order to this effect that will indicate that the escrow will continue to be paid by the defendants in this case to this court. That the escrow will not even be considered to be released until such time as the highest court that this case is appealed to has. I want it specifically in that language so that everybody doesn't have to come back here running up attorney fees, asking me to do something I'm probably not going to do.
Thank you, Your Honor. Your Honor, this has nothing to do with the case.
Your Honor, I want to make sure the same amount you didn't mention on the record.
It's the 2,500. Yes, sir.
Years ago, can I ask you a question? Do you remember years ago, a girl on a Friday, I can't remember how many years ago, it's probably 15 years ago, coming in here and asking you were in your chambers, you were the only one left, about a black jet passing her?
A black jet?
Passing her, a car, but she called it a black jet. No, I just wanted to know her name. She came and specifically talked to you. And what it was an alarm went off at my building in Plymouth, and I was speeding to get it. I got pulled over by Washington County. But I passed 3 young ladies from this court. This was 2:00 in the morning. The alarm went off. And thank God you were here that Friday, because my court date expired that day and I would have had a warrant out for me for the theft. And she came to you, but I always wanted to thank her, but I don't know who she is.
I can't recall it specifically, sir.
But you got it handled all over the phone. It was pretty cool.
Right.
Thank you.
No, thank you for that.
Okay.
Thanks, Your Honor. I'll prepare the order.
Thank you.
Thank you, sir.
Thank you. Have a good weekend.
You do the same.